termination of his appointment with the defendant until the termination of this suit and payment of same to the claimant. 4. Payment of the sum of 20 million naira to the claimant by the defendant being general damages for unlawful termination of claimant's employment. 5. Payment to the claimant of the sum of 30 million naira general damages for libel contained in the defendant's final report, wherein the claimant was said to have been guilty of theft of 3 air conditioners. 6. A letter of apology from the defendant to the claimant for the aforesaid libel and a retraction of the guilty verdict passed by the panel on the claimant. 7. Payment of the sum of 30 million naira damages for unlawful, unwarranted, and malicious report to the police and prosecution of the claimant for the theft of 3 air conditioners. 8. Payment of 10% interest on the judgment sum from the date of judgment until final liquidation. Upon receipt of the originating summons on the originating processes commencing this suit, the defendant, with the leave of court, filed his statement of defense dated and filed on the 26th day of April 2019, and the claimant, in response, filed his reply to the defendant's statement of defense dated 1st November 2019, but filed on the 1st of November 2019. After the settlement of pleadings by both parties, trial in the suit commenced, with the claimant, Mr. Ayo Olofeku, testified as CW1. The claimant adopted his written statement on oath. He also called 2 other witnesses, namely Mr. Dixon Ajulo as CW2 and Mr. J.O. Olofeku CW3, respectively. On the 27th day of October 2020, the court granted the claimant leave to amend the name of the claimant by substituting Nikon Insurance Insurance Limited with Nikon Insurance PLC. At the conclusions of the claimant case, the defendant elected not to call any witness to give evidence in support of his statement of defense. The defendant rested its case on the case of the claimant. Consequently, parties were ordered by the court to file final written addresses in line with Order 45 of the Rules of Court, beginning with the claimant, since the defendant did not present any witness to testify. I have, in the body of the judgment, reproduced the summary of the evidence and pleadings of the parties. I think due to time constraint, I shall skip reading out the evidence, the pleadings and evidence which the parties already have. I go to the submissions of the counsel, starting with the claimant. The claimant formulated 5 issues for determination. The 5 issues are: 1, whether or not the defendant's act of setting up a panel to investigate theft of 3 air conditioners and which convicted the claimant for their theft was not unconstitutional, ultra biased, illegal, and therefore null and void. 2, whether or not the report of the panel set up by the defendant to investigate and try the persons suspected to be involved in theft of 3 air conditioners and which found the claimant guilty of the theft of the air conditioner is libelous to the claimant, for which he is entitled to damages. 3, whether or not the report of the claimant to the police, which culminated in the torture of the claimant. And let me cross-check, because the way it was looked like that issue number 3. whether or not I'm reading from the address of counsel now, whether or not the report of the claimant to the police is correct, what I quoted is correct. So I shall continue with my, whether or not the report of the claimant to the police, which culminated in the torture of the claimant and his resultant trial over the safety of 3 air conditioners, is not unwarranted and malicious, for which he is entitled to damages. 4, whether or not the termination of employment of the claimant, which was not in accordance with the terms and conditions of service of the defendant, is wrongful, unlawful, for which the claimant is entitled to be paid all his salaries and entitlement also damages. 5, whether or not the claimant is entitled to 10% interest on the judgment debt if there is default from the time set by the court to pay it until final liquidation. The argument of counsel on the 5 issues have been captured in the body of the judgment. So I think for purposes of due to time constraint, I shall also skip reading the argument. Counsel, when they got the hard copy, they will see the argument captured therein. I now goes to the submissions of the defendant. The defendant formulated only single issue for determination. That is to say, whether on the preponderance of evidence the claimant has established his claim to entitle him to the grant of the relief sought by him in this case. However, counsel for the defendant argued the 5 issues formulated by the defendant in his final written address. The argument have been captured. I will also skip reading the argument. Counsel, when they receive the hard copy, will see will read the submission. The claimant, in response to the final written address of the defendant, filed a reply whereby he responded to the issues raised in the defendant's final written address. Counsel distinguishes some of the cases that were cited by the defendant and submitted that they are not relevant to the determination of this case. And counsel insisted on the case of Iguilo as the case that is relevant to the determination of this case, which he said is on all fours with the case at hand. So the argument of counsel on the reply have also been captured in the main body of the judgment. I shall also skip those arguments. I shall go straight to the decision of the court. This is the court decision. I have carefully and painstakingly perused and considered the processes filed in this suit. The claimant formulated 5 issues for determination, while the defendant, who did not give evidence in support of his pleading, in support of the pleading filed before the court, formulated a sole issue for resolution. But in arguing the issue, counsel adopted and argued the 5 issues submitted by the claimant. It is an elementary principle of law that a party who failed and neglected to testify in support of his pleading is deemed to have abandoned his pleading, and the case put forward before the court as done by the defendant in this case is deemed to have been abandoned. Therefore, the defendant, by refusing to adduce evidence in support of the statement of defense, filed before the court is deemed to have abandoned the pleadings and the case put forward in the defense. This means that there is no defense before the court and the defendant has abandoned his defense. However, I shall quickly add here that the mere fact that the defendant has abandoned his defense does not guarantee the success of the claimant. The reason being that the claimant has to convince the court that by evidence he has adduced before the court, he has proved his case by minimal requirement of proof. The evidence also must be of such a quality that command evidential value. This proposition of the law is predicated on the fact that absence of defense does not automatically translate to claimants automatically having judgment given in his favor. By the minimal evidential requirement, a claimant should not expect the court to give in his favor judgment just because the other party did not adduce any evidence before the court. See the case of Mr. Lawrence Azenebo versus Bayero University, Kano, reported in 2011, 25 NNLR, part 70, page 45, at 69. See also the case of Ogunyade versus Oshunkeya, reported in 2007, for Nigeria Ukilolo report, part 1057, page 218. See also the court decision, this court decision in the case of Attorney General of Osun State versus NLC and others, reported in 2013, 34 NLLR, part 99, page 278. It behoves of me at this juncture, before delving into the main claim of the claimant, to thrash out some preliminary issues that emerge in the addresses of both counsel. I shall start with the issue of applicability of public service rules in resolving dispute submitted to the court, in this case by the parties for resolution. The counsel for the defendant had in his final written address copiously made references to the public service rules and submitted that the defendant has complied with the rules and determination of employment of the termination of the employment of the claimant, that it was done in line with the rules. The counsel for the claimant disagreed with the position of counsel for the defendant. Counsel for the claimant has argued that public service rules are not the appropriate terms and conditions governing the claimant's employment. Counsel posited that it amount to approbation and reprobation for counsel to the defendant to argue in support of public service rules when counsel had insisted that the defendant is not a government agency. The counsel for the claimant has, however, insisted in his pleading and evidence before the court that the defendant being owned by federal government, the claimant's employment has statutory labor. I quite agree with the counsel for the claimant that the defendant, having abandoned his pleading, he had no facts to fall back different from the pleadings of the claimant. I have thoroughly examined the claimant's pleading. There is nowhere the claimant pleaded that the terms and conditions of service governing the employment of the claimant include public service rules. The abandonment in the claimant's claim, in the claim of the claimant, clearly shows that the claimant's employment is governed by the terms and conditions of service of Nikon
It's not your system, it's from my lord. So let's just stay tuned.
I'm sorry, Council. I'm sorry for the disruption.
As the call, please.
As the call, please, my lord.
I'll continue from where I had to change my device. I'll continue from where I stopped. On the claim by the claimant that his employment has statutory flavor, a careful appraisal of the argument can base on the issue of claimant's employment being one with statutory flavor will show that there is nothing that clearly invests employment of the claimant with statutory flavor. Exhibit CW1N, the letter of appointment, Exhibit CW1M, letter of confirmation, and Exhibit CW1O, letter of increment, clearly reveal that the claimant was employed by a public liability company which has terms and conditions of service governing employment of its staff, including the claimant. I will agree no more that the claimant's employment is not closed with statutory flavor, nor was it guided by public service rules. There is nothing in the evidence before me to show that claimant was employed by the Federal Civil Service Commission, the body constitutionally empowered to make employment into the Federal Public Service of the Federation. Since the claimant was not employed into the Federal Public Service, the public service rules is inapplicable to determination of the priority to determination of the propriety or otherwise of determination of claimant's employment, as the defendant would want this court to do. In the circumstances, the public service rules cannot be used to determine employment of the claimant. Exhibit CW1N clearly shows that the claimant was employed, clearly shows who employed the claimant. The claimant's employment having not been done under the public service rules, and the letter of employment having not incorporated the public service rules as conditions of service, the defendant has no basis invoking the said provisions in arguing that the termination of employment of the claimant was in line with the public service rules and is proper. It is glaringly clear from Exhibit CW1N, letter of employment, Exhibit CWAM, letter of confirmation, and Exhibit CWO, letter of increment, that the defendant was a public liability company as at the time the claimant was employed, had his confirmation and appointment and increment. This means that the defendant was incorporated under the Companies and Allied Matters Act. There is also evidence before the court which shows that the defendant, as a result of commercialization stroke privatization, transformed into a private limited liability company. The defendant, as an entity duly incorporated under the Companies and Allied Matters Act by Section 37, is duly invested with legal personality to conduct its affairs, including appointment of suitable persons into its service. The claimant has, in fact, agreed to this position. Has agreed to this position by his last amendment to the originating processes before the court. I shall point out here that whether the defendant is wholly owned by the federal government, that does not make employment of its officers to be governed by public service rules, or invest in the employees, included the claimant, with a contract of service that is protected by statute, or what is termed as statutory labor, without more, so as to invest it with a special status and removed it from master and servant employment relationship. See the case of Okomu Oil Farm Company Limited versus Siserahin, reported in 2001, 6 Nigerian Workload Report, part 710, page 660. See also the case of Bullet International Nigeria Limited and another versus Olani, reported in 2017, LFELR 4247SC. See also Papuade versus Obafemi Awolowo University Teaching Hospital. Therefore, I hold that the claimant's employment, having not been made under public service rules, the defendant cannot be had to argue that the defendant complied with the provisions of public service rules in terminating the claimant's employment. It is also my finding, based on the evidence before me, that the public service rules are not applicable to the claimant's case, as the employment of the claimant is not one governed by the public service rules. The claimant's employment is equally not that with statutory labor. It must always be borne in mind that the fact that an employer is a creation of status or statutory body does not, without more, raise the legal status of the employee over and above normal common law master and servant relationship. The fact that an employee is a federal public servant and the employer is created by statute do not on their own elevate the employee's contract of employment to a contract with statutory labor. Also, the fact that a person is pensionable does not mean that his contract of employment is protected by statute. Whether a contract of employment is governed by statute or not depend on the interpretation of the contractual document or the applicable statute. In the instant case, what was before the court was Exhibit C, CW1N, letter of employment, CW1M, letter of confirmation of appointment, CW1O, letter of increment, and CW1J, 1 to 21, the conditions of service. This exhibit clearly shows that the claimant was employed by a public liability company. There is nothing in this exhibit to suggest that the claimant's appointment was made pursuant to any statute, or that the appointment is governed by statute. There is no indication that the claimant was employed under the public service rules to make his appointment to be governed by the public service rules. Since there is nothing to support claimant's employment having statutory labor, the employment cannot give rise to special treatment by way of statutory or legal labor in the event of the master deciding unilaterally to terminate the appointment of his servant, as it was done in this case. See the case of Ilo Bachi versus Phillips, reported in 2002, 14 Nigerian Workload Report, part 787, page 600 and page 264. See also the case of Olatu Bosun versus NISA, reported in 1988, 3 Nigerian Workload Report, part 80, page 25. See also the case of Al Hassan versus Ahmad Bello University Zaria. See also the case of Isewore versus NEFA, I shall now deal with the having determined the status of the employment of the claimant. Having determined the status of the employment of the claimant, I shall now proceed to deal with the claimant case as presented before the court. It is the law that a claim is circumscribed by the reliefs being sought by the claimant, and the claimant is bound to adduce evidence that is enough to prove his case. In the case at hand, parties have joined issues as the defendant has filed statement of defense. It is settled that once pleading have been settled, the issues joined, the duty of the court is to proceed to trial of the issues. If one party fails or refuses to submit the issues raised in the pleadings for trial by giving or calling evidence in support, as was the case here with the defendant, the court must, unless there are other legal reasons dictating to the contrary, resolve the case against the defaulting party. That is, that refuse to lead evidence in support of his pleadings or of his pleading, which translated into voluntary abandonment of his case before the court. See the case of Imana versus Robinson, reported in 1979, 3-4 SC1. The defendant in this case decided not to call his witness to testify in proof of the defense put forward before the court. This means the defendant rested his case on that of the claimant. What this means is that the defendant, by resting his case on that of the claimant, he stands or falls by the evidence of the claimant. In the instant case, the defendant did not deem it necessary to give evidence. He rather rested his case on that of the claimant. The court will determine the case only on the evidence of the claimant. See the case of Duros Saro versus Ayolinde, reported in 2005, 8 Nigerian Ukilolo Report, Part 9, 27, page 407 SC. As pointed out earlier in this judgment, refusal of a party to give evidence does not automatically guarantee the claimant getting judgment in his favor, as the law still requires him to adduce evidence in proof of his case. In the case at hand, the reliefs being sought by the claimant are of a mixture of declaratory and special damages. The claimant who seeks judgment to be given in his favor is required by law to produce adequate, credible evidence in support of his pleading. And where there is none, then the abatement in the pleadings are deemed abandoned. The same principle of law goes to whatever defense a defendant seeks to rely on in the process of demolishing the case against him. In the instant case, the defendant did not adduce any evidence in support of its case, therefore did not discharge its duty, as it is the duty of every party to assist court in arriving at a just conclusion. See the case of Arabambi versus Advanced Beverages Industries Limited, reported in 2005, 19 Nigerian Ukilolo Report, Part 959, page 1. Therefore, the case of the claimant stands or falls upon his own evidence and not upon the weakness of the defense or absence of evidence or admission. The reason being that some of the reliefs are for declaration and some others special in nature. The evidential rule of he who asserts must prove still applies. Looking at the pleadings of the claimant case must be determined on the reliefs being sought before the court. in Gabriel Atibi, C. Gabriel Atibi, in Gabriel Atibi versus Kabel Metal Nigeria Limited, reported in 2008, LPLR 591 NC, reported also in Weekly Law Report Part 1095, 399. The Supreme Court has this to say: a claim is circumscribed by relief's claim. The duty of a plaintiff, therefore, is to plead only such facts and materials as are necessary to sustain the reliefs and adduce evidence to prove same. In other words, since the claim is circumscribed by relief's claim, it is the reliefs that the court use in determining the case of the claimant. I shall now consider the reliefs being sought by the claimant vis-a-vis the evidence adduced to see whether the claimant has proved his case as required by law. Relief 1 is for declaration that the investigation and or trial of the claimant by the defendant's panel and is finding which held the claimant guilty of theft of 3 air conditioner is unconstitutional, ultra-biased, illegal, and is null and void. The claimant, in attempt to prove this head of relief, has averred that on 2nd day of October 1998, he discovered that 3 air conditioners kept in the office of the defendant at Imani Estate were missing. Consequently, he reported the missing air conditioners to HNB Security on duty and his senior manager. Shortly after the report of the claimant was interrogated by the security supervisor of HNB Security, who alleged that the claimant must have known about the missing air conditioners. The claimant was later arrested by the police on complaint of HNB Security and the defendant. The claimant, together with one staff of the defendant and some personnel of HNB, were charged to court for theft of the 3 air conditioners. After the claimant was arrested by the police, the defendant set up a panel of investigation on the alleged theft of the air conditioners and to make a necessary recommendation to the defendant as to culpability of the claimant and Mr. Chonkia, one of the staff of the defendant. The panel investigation, after calling witnesses at the end of its assignment, found the claimant guilty of theft and made recommendation accordingly. The final report is Exhibit CW1B 1-9. It is submitted by counsel for the claimant that the defendant does not have power to usurp the power of the police to set up investigation panel to investigate crime. That the panel does not have the power to find the claimant guilty of theft. Counsel asked the court to hold that the investigation and finding of the panel as contained in Exhibit CW1B 1-9 is unconstitutional, illegal, ultra-biased, the powers of the panel null and void. The counsel for the defendant has argued before the court that the defendant has power to set up panel of investigation and findings of the panel is in order. The law is now settled that an employer has the right to set up an administrative panel of investigation to inquire into acts of misconduct against its employee, even if the act involves commission of crime, but the power does not extend to that of criminal court to try an employee and find him guilty of the crime being investigated. See the case of Awala versus Nitel Sufra. Exhibit CW1B 1-9 is the report of the panel of investigation, which purportedly found the claimant guilty of theft. However, a careful scrutiny of the said report, Exhibit CW1B 1-9, will show that it is defective in the sense that one of the members of the panel that investigated the claimant, i.e. the secretary of the panel, did not sign the report. The claimant has in his pleading and evidence stated that the secretary of the panel, by name V.A. Yakase, has told him the report is ultra-biased, the powers of the panel. Surprisingly, the said secretary was never called to testify before the court. In the circumstances, the Bible boasts evidence of the claimant on what he was told by the secretary of the panel without the secretary being called to testify amount to hearsay, and same must be rejected. I so reject that piece of evidence regarding what the secretary told the claimant regarding the report of the panel. The normal things to do for a member of a panel, if he really disagree with the majority, is to write a minority report. In the absence of such a minority report being written by the said secretary, the panel report has no evidential value for the absence of signing of the same. It is an incomplete document which the court should not apportion any evidential value to it. In view of this, exhibit CW19 1 to 9 has no evidential value. Same is hereby discountenanced for the purposes of this judgment. Furthermore, exhibit CW1B 1 to 9 is an incomplete document in the sense that it starts with page 2. The first page was missing and no explanation from the claimant as to what happened to page 1 or why the said page was omitted. This clearly goes to strengthen the to confirm that the document is an incomplete document. The law is right that document must be tendered as a whole rather than in piecemeal or in parts, or as the court noted in Zenith Bank of Nigeria PLC and another versus Chief Janice Ekweruwem and another reported in 2012 for Nigeria Okilolo Report Part 1290, page 207 and 236. Pockets convenient to a party, and a party is not to choose extract therefrom. That is convenient to his case. The rationale for this position is to enable the court an opportunity to have a holistic view and understanding of the document tendered. Where references is made to a document, where a document is not complete, the court will not be able to have the opportunity of knowing or even construing the document to give it a meaning that is intended for it. It is a law that a court has a bounden duty to ensure documents improperly admitted as exhibit at trial without objection are discountenanced, notwithstanding that it is a stage of evaluation of the document. The Court of Appeal in Timothy and another versus Okefin and others reported in 2018, LPELR 44182, quoting B. Mfang Nigeria Limited versus MSO1 Limited, 2007, 14 Nigeria Okilolo Report, Part 1053 at page 139, paragraph H, stated the position of the law as follows. The law is elementary. The law is elementary that a trial judge has the right to expunge from the record a document which he wrongly or wrongfully admitted. He can do so suo motu at the point of writing judgment. He need no prompting from any of the parties, although a party is free to call his attention to the document at stage of address. In line with the settled position of the law and my finding that exhibit CW1B is incomplete for omission of the first page and absence of signature of the secretary of the panel, the document having been found to be incomplete is wrongfully admitted as exhibit in this case. I therefore expunge it from the record of the court and shall place no reliance on it in the determination of this suit, as it lacks evidential value. It is pertinent to point out that the law is not absolute, that simply because documents have been admitted, the court must utilize them. The court has a bounden duty to ensure that for document to be admitted, before the court have the evidential value before they can be acted upon. The law is settled that where such inadmissible evidence or document was erroneously or wrongly admitted in evidence in the course of trial, the court, in writing judgment, has been mandated, invested with the requisite bias to expunge such a document or disregard such evidence in arriving at a decision in the case, since a court can only act or rely on legally admissible evidence that has evidential value. See the case of Magaji versus Ogele, 2012 LPLR 9476. See also Amechi versus Solaja, 2017 LPLR. See Royok Nigeria Limited versus CJ Sokoto and another. See all and another. The reliance on exhibit CW1 B1 to 9 by the claimant is therefore based on misconception of law. On the whole, and for the reasons given above, I hold that the exhibit CW1B9 has no evidential value. This court cannot act on it. The said exhibit is hereby discountenanced for the purpose of this judgment. In view of the rejection of exhibit CW1B1 to 9, which the claimant relied in proof of relief 1, the declaration sought has not been proved and same is hereby refused. Relief 1 is hereby dismissed. Relief 2 is for declaration that termination or appointment of claimant is unlawful and not in accordance with the terms and conditions of service, therefore null and void. The evidence before the court on this head of relief is that after the claimant was arrested by the police, the defendant set up a panel to investigate the alleged theft and to make a necessary recommendation to the defendant as to the culpability of the claimant and Mr. Chonkia in the theft of the 3 air conditioners. The panel, after calling evidence, submitted its report where claimant was indicted. Being aware of the negative effect of the final report would have on the claimant's employment with the defendant, coupled with the fact that the case was with the police and court, the claimant solicitors wrote to the defendant about the illegality of setting up a panel to try the claimant for alleged crime of theft and asked the defendant to set aside the panel's finding and recommendation as they affect the claimant. See Exhibit CW1C1 to 3. It is the case of the claimant that during the trial at Chief Magistrate Court Wuse Abuja, the claimant was initially placed on suspension from 14th of January 1999. See Exhibit CW1G, letter of indefinite suspension. However, immediately the defendant received Exhibit CW1C 1 to 3, the defendant was highly infuriated and promised to teach claimant a lesson. Consequently, the defendant wrote to the claimant lifting his suspension. See Exhibit CW1F, letter lifting suspension dated 15th day of April 1999. Upon resumption on duty from the suspension, the claimant, by the letter dated 20th day of April 1999, wrote a report on the position of the criminal case at the Magistrate Court Wuse Abuja. See Exhibit CW1E, report on trial at Magistrate Court. According to the claimant, in late May 1999, the defendant started asking him why he has to ask his lawyer counsel to write demand notice to the defendant and that he would be taught a lesson of his life, that as a thief, he should show remorse rather than fight for his right. That is early June. The claimant was sometimes locked out of office. This action led to the claimant on the 8th of June 1999 to file an action at Federal High Court Abuja to stop defendant from terminating his appointment. On the 15th of June 1999, the Federal High Court granted injunction restraining defendant from terminating claimant's employment. That instead of obeying order of the injunction, the defendant threatened claimant never to enter its premises again. The counsel for the claimant wrote to the defendant about the disobedience of the court order. See Exhibit CW1H, letter of 21st day of June 1999 on disobedience of court order. But the defendant alleged it had terminated the claimant's employment. It had terminated the claimant's employment. The counsel for the claimant refers to page 8 . Refers to page 8. The counsel for the claimant refers to Before proceeding further, I shall comment on the issue of case filed by the claimant at Federal High Court on the 8th day of June 1999, wherein the claimant obtained order of injunction, interim injunction, with exhibit CW1I 1 to 29, that is the judgment of the Court of Appeal, which found that the Federal High Court does not have jurisdiction in respect of the matter that was filed before the Federal High Court. It means all what has been done in the said suit of 8th day of June 1999, including the interim order of injunction and the final judgment, have been vacated by the Court of Appeal, and there was nothing, as if nothing has been filed by the claimant as at 8th of June 1999. The counsel for the claimant refers to page 8, chapter 4 of the conditions of service exhibit CW1J 1 to 21, which make provisions for suspension, and submitted that the claimant can only be lawfully suspended under ground 1B after he has been issued with a query. However, in the present case, the claimant testified that he was never at any time issued with a query. It is also submitted that another lawful way of suspension is under Section 4(2) if the claimant is being prosecuted for a criminal offense, as was the case here. The suspension could extend to 1 year. However, in this case, before the disciplinary action can be taken against him, as provided under under subsection 2, the claimant must have been found guilty or convicted. Termination of appointment can then be invoked as provided under section 4C, which is under chapter 4 of the disciplinary procedure. According to counsel, in the case of the claimant, he was placed on indefinite suspension in a letter dated 14th day of January 1999, and he was discharged of the crime by the Chief Magistrate Court on the 6th of October 1999, which is within 1 year. The suspension was based on the criminal prosecution of the plaintiff at the Chief Magistrate Court. It is submitted by counsel that from the foregoing, the claimant's trial lasted for less than 1 year, which entitled claimant to have salary within the period. Counsel also posited that without waiting for the outcome of the criminal trial, the claimant was recalled from suspension and his appointment as claimed by the defendant to have been terminated in April 1999, when the trial at the magistrate court was still ongoing. Counsel contended that the said termination was not in accordance with the conditions of service of the defendant, which applies to their employee, including the claimant, and is therefore unlawful, null and void. Counsel submitted that the defendant did not bother to wait for the period stated above before purporting to absent letter of termination of employment of the claimant to his hometown in Ekiti State. It should be noted that the claimant up to date has not seen the said letter of termination, and the defendant has not made any copy available to the said letter before this honorable court. Counsel submitted that what is clear is that the claimant was placed on indefinite suspension in a letter dated 14th January 1999, and he was discharged of the crime by the Chief Magistrate Court, which is less than 1 year, and 1 year of the placement on suspension. In the circumstances, the defendant has not followed provisions of Chapter 4(2) of the Condition of Service. Counsel asked the court to so hold. The defendant, in his final written address, has argued that the employment of the claimant with the defendant is not governed by National Insurance Corporation of Nigeria terms of conditions of service. In support of this contention, counsel relied on argument canvassed in the defendant's final written address at paragraphs 21 to 26 of the address. Counsel insisted that the termination of the employment of the claimant by the defendant was lawful. I must state without any equivocation that the reliance by the defendant on the case of FUT Yola versus Mawia Sufra is misconceived, as the said case is not on all fours with the case at hand. I have earlier in this judgment found that the claimant's appointment was not made under public service rules. Therefore, the public service rules are not applicable to this case. I have also found that the claimant's case is not that which is laced with statutory labor. The employment relationship between the claimant and the defendant is that of master and servant, or what is termed as employment under common law. Therefore, all the argument canvassed by the defendants on the public service rules is hereby discountenanced for being irrelevant and inapplicable in this case. It is clear to me from the state of pleading evidence before the court that the claimant employment is governed by XBCW1N letter of appointment and XBCW1J1 to 21, the conditions of service governing claimant's employment. The claimant's grounds on this head of relief is that defendant purportedly terminated his employment while he was still facing a criminal trial at the Chief Magistrate Court, Wuse Abuja, and while he was still on indefinite suspension. According to the claimant, the defendant should have waited until the end of trial before terminating his employment. The law on termination of employment is very clear and without any doubt that parties in a contract of service are bound by the agreement governing the employment, or what is termed as terms and conditions of service, which is the bedrock on which the rights and obligations of the parties under the contract of employment could be settled. In law, the concern of the court when it comes to the issue of determining appropriateness or otherwise of termination or appointment is the service agreement, i.e. to say the letter of appointment and the terms and conditions of service. The service agreement or letter of termination is one of the most vital documents the court construe in determining the rights and obligation of the parties under the contract of service. See Anaja versus UBA PLC 2014 4 ACLR 78. This means every contract of service is regulated by agreed terms and conditions of service. What is termed employee staff handbook or human resource policy. Therefore, the intention of the parties is gathered from the letter of employment and conditions of service. The court is only obliged to examine the words used since the court expressed the intention of the parties. See Longe versus FVN, reported in 2010, 6 Nigerian report, part 1189, page 1. This principle is rooted in the tried position of the law that parties are bound by the terms agreed in contract of service. If the conditions for the performance of a contract are fulfilled by the parties, therefore they will be bound. It is not the function of the court to make contract for the parties or rewrite one which they have made. Court has no power to alter, tamper with agreed terms of the parties. The duty of the court is to construe agreement, to discern the intention of the parties and effect same. See UBN, Union Bank of Nigeria versus Ozigi, reported 1994, 3 Nigerian report, part 333, page 384 to 404. What is clear from the evidence before me is that the claimant is contesting validity of termination of his appointment by the defendant, which was formally communicated to him, which was not formally communicated to him, that he got to know about the termination of his appointment by the defendant via affidavit filed by the defendant at Federal High Court. It is tried law that termination of employment can be written or oral or by conduct. I must, however, state that for any of the method that is deployed in terminating termination, the condition of service on termination must be complied with. The defendant in his abundant pleading asserted that the letter of termination of appointment was sent to the claimant to his home address at Ekiti State. Because the claimant refused to collect the said letter, the claimant has denied ever being served with the letter of termination. In view of the denial of the claimant of receipt of the letter of termination, the defendant is duly bound to adduce evidence in proof of service of the letter of termination on the claimant. The defendant having alleged to have posted or sent the letter through courier would have discharged the burden of proof on him by reproducing receipt or acknowledgement from the courier service, which has not been done. In the circumstances, I have no hesitation in coming to the conclusion that the defendant never served the claimant with letter of termination. A similar situation arose in the case of University of Ilorin and others versus Dr. Mrs. Azi Imonokome Obayan, reported in 2018 LPLR 439106, where the Apex Court held that employer who allays service on employee must prove the said service. The defendant, having failed to prove service, has not sent any letter of determination of claimant's employment at Ekiti as alleged by the defendant. The provisions of Chapter 4 of Exhibit CW1J 1 to 21, the conditions of service are very clear and unambiguous on how the defendant should go about in terminating claimant's employment, even in situation where the conditions of service are silent on the procedure to be followed in termination of appointment. An employer has the bounden duty to afford the claimant right to be heard. In this case, there is no iota of evidence to show that or establish that the claimant was queried or a disciplinary committee set up to try the claimant for misconduct. The purported committee set up by the defendant, which this court rejected its report, was not a disciplinary committee, as it is an ordinary investigative committee. What is clear in this case is that all that the defendant did was to suspend the claimant from work on grounds that the claimant had been charged to court for a criminal offense. After about 4 littered CW1F. Upon resumption of duty, the claimant wrote Exhibit CW1E, a report intimating the defendant on the criminal trial at the Chief Magistrate Court, Wuse Abuja. The claimant on 8th of June 1999 instituted an action at the Federal High Court. It was there that the claimant got to know about the termination of his appointment. It is clear from the above analysis that the defendant did not follow due process in terminating the appointment of the claimant. It is manifestly clear that the defendant was in a haste to deal with the claimant, throws away all cautions that he ought to have observed in determining the claimant's employment. In the circumstances, it is my view that the termination of claimant's appointment was wrongful for having not been done, for having been done in contravention of the extant provisions of the Condition of Service, Chapter 4, Chapter 4 of Exhibit CW1J 1 to 21.
As the court pleases.
Or relief 3, which is for an order directing defendant to calculate all salaries, entitlement allowances, and severance package of the claimant equivalent to his rank, i.e. Band 9, and the pension from the date of unlawful wrongful termination of his appointment with the defendant until the termination of this suit and payment of same to the claimant. According to counsel for the claimant, the termination of claimant's employment was unlawful, wrongful. The claimant is entitled to his salaries from the date of termination and payment of pension. Counsel went on to argue that this case is on all fours with the case of CBN versus Iguilo, reported in 2007-25 WRN page 1. In the suit of Mr. Iguilo, an employee of Central Bank of Nigeria, he was alleged to have acquired for the library used and mutilated books, many of which were of no use for the bank's library. He appeared before the disciplinary committee and he denied the allegation made against him in an unsigned, anonymous petition written against him. For the defendant, it was argued that the argument of the claimant on the case of Iguilo versus CBN Sufra is quite strange and absurd in view of tried positions of the law that he who asserts the existence or state of facts has the onerous binding duty to prove same. On this submission, reliance was placed on the case of Sankey Onai Feke and Tori versus MFSN and host of other cases cited therein. The Court of Appeal where the Court of Appeal stated that loss of earning or anticipated profit is in the nature of claim of special damages. Reliance was further placed on the case of Ibrahim versus Garki, and where won by JSC, while quoting the case of where Wambe JCA, while relying on the case of the Benin Rubber Producers Limited versus Ojo, where she quoted Ugu, clearly shows that claim for salaries and pension are claims for special damages, which have to be particularized and strictly proved. This is because they are the type of that the law will not infer from the nature of the act. They do not follow in the ordinary course of event, but are exceptional in character and of necessity proved. It is submitted that in the instant case, the claimant who has not specifically pleaded and proved his income and loss of the same is now shifting the burden of doing so on the defendant. This is quite absurd and at variance with the position of the law as cited above. Counsel asked the court to dismiss this leg of the claimant's claim as he has not specifically pleaded and proved same to warrant a grant of same to him by the Honorable Court. A reply on point of law, counsel insisted that the case of Iguilo is applicable to this case. The law is well settled beyond any reproach that claims for salaries, entitlement, or pensions are in the class of claim for special damages, in which the law requires the claimant to specifically plead and strictly prove for the claimant to succeed. I have examined case of Iguilo versus CBN, on which claimant heavily relied in making his case, and I found that case to be in a class of its own. The said case is not on all fours with this case, as the claimant wants the court to believe. Therefore, it is not relevant in the present discourse. The case of Iguilo is a case in which a disciplinary committee was set up, and the committee exonerated the employee from any blame. While waiting to receive letter of exoneration, he received letter of termination. The claimant in the case at hand, the claimant in that case died while the case was still ongoing. But in the case at hand, there was no disciplinary committee set up to try the claimant. Let me reiterate that the law is elementary that claims for salaries, emolument, allowances, pension, and other benefits accruing to an officer or holder of an office are in the nature of special damages for which strict proof is required. In the instant case, the claimant's claim for salaries, entitlement, benefit, and cannot be different. However, what is clear is that there was a dearth of proof in the evidence presented by the claimant. Furthermore, the relief in the way it was couched was vague. It is to be noted that by strict proof of special damages, the law means that a party claiming special damages should establish his entitlement to them by credible evidence of such a nature or character that will suggest he is indeed entitled to them. See MultiChoice Nigeria Limited versus MCSN Nigeria Limited, reported in 2020, 13 Nigeria Nuclear Report, Part 17, 42, page 415. In the instant case, in proof of this species of damages, the claimant did not itemize or particularize the special damages, nor provide the quantum of his claim. The way and manner, really 56, the way and manner, the relief on payment of salaries was couched shows the confusion in which the claimant found himself. The claimant has exhibited ignorance of his own salary and other entitlement, which he had been enjoying before they were stopped by the defendant. The relief in the way it was presented in the claim is vague and imprecise. For the court to grant this kind of claim, it must speculate, which the court is precluded from indulging. The court will not indulge in speculation for the court to be able to determine the claim on salaries and entitlement. The claimant must have specifically plead the claim and establish how he arrived at the quantum being claimed. The claimant in this case has not specifically pleaded has not particularized his claim, nor state the quantum of his entitlement. The claimant was economical with the facts regarding his claim for salaries and entitlement. The law is right for a party to be awarded any release by a court of law. That party must not only plead with particularity, but also prove by credible, convincing evidence that he is indeed entitled to the relief he is seeking. A court of law has no jurisdiction to grant to a party that which he has not asked for. The court ought not to play the role of Father Christmas, which can go around granting to parties reliefs which they have not asked for. See the case of Odofin versus Agu. See also Okoko versus Dakolo. See also I am Boye versus Balogun, and host of other cases cited therein. The Apex Court was faced with a similar claim in the case of University of Jos versus Dr. MC Ike Goha, reported in 2013, 8 Nigerian Employee Report, part 1360, page 478. The court refused to grant the reliefs due to its vagueness. The Supreme Court, at page 498, paragraph CG, has this to say: a claim that is vague and lacks certainty is no claim at all. In the instant case, in paragraph 13b of the respondent's statement of claim, he sought an order directing the appellant to confirm him as a lecturer in the Department of Political Science of the University of Jos, with effect from 27th day of January 1995, with all my promotions, allowances, and entitlement. The respondent did not state with certainty what his allowances and entitlement were and how he earned his promotion from one grade to another grade and for which period. These vital facts were not backed by evidence. All the reliefs regarding promotion, allowances, entitlement were vague, uncertain, unascertainable, and lacking in particulars and proof by evidence. All the reliefs pertaining to promotion, allowances, and entitlement being reliefs that were vague, uncertain, and lacking in particularity and proof by evidence. End of quote. On payment of pensions, it is It is to be noted that the claimant, apart from his failure to particularize and strictly prove this claim, has not referred to any of the provisions of the condition of service that and just and he based his claim on guesses. On payment of pension, it is usually paid when an employee has, for one reason or the other, left service of the employer, not on ground of dismissal, and he had served for a certain number of years or minimum period for qualifying to be entitled to pension. The claim for pension here is being based on termination of employment. Since the defendant was not dismissed from service, he may be entitled to pension if he qualifies for it and was able to establish that by the conditions of service, he is entitled to pension. The claimant in this case has not referred the court to any provisions of the conditions of service, Exhibit CW1J 1 to 21, where payment has been provided for him. The claimant, in an attempt to establish his entitlement to pension, has pleaded in his reply to the statement of defense that all categories of employees who worked with him before termination of his employment with the defendant were captured for payment of pension after their retirement. Who worked with him were captured for payment of pension after their retirement with the Pension Transition Arrangement Directorate, and the dependent paid their terminal benefit. The claimant also pleaded a press release by PTAD on the settlement of 759 next of kin of defunct privatized companies, of which defendant was listed as number 4. The claimant has abandoned his pleading on issue of entitlement to pension by failing to tender the document pleaded, as the law is right that pleaded documents not tendered means abandonment of pleading in respect thereof. Where a document is pleaded but not tendered, the paragraphs of the pleading is deemed abandoned. See Solar Construction Services Limited versus Honorable Minister of FCT, reported in 2018, LPELR 46648. See also Oba AA Oyediran versus His Royal Highness Oba Alebiosu II. Where Kutigi JSC, as he then was of blessed memory, has this to say. About the letter pleaded in paragraph 10 of the third respondent's statement of defense, and which was not tendered, the law is simply that paragraphs of the pleading is deemed to have been abandoned. The claimant in this case should not expect this court to do his job by scouting and fishing out his pay slips wherever they are hiding in proof of his salary, and whatever he is entitled to the claimant cannot shift his responsibility to the defendant or to the court. It is also to be noted in labor jurisprudence, a claimant must base his claim on his own right and not on entitlement of others. This position was made clear in suit number in the case of Mr. Gabriel Aguno versus John Holt PLC. I reported suit number NICM/LA/349/2013, the judgment of which was delivered on 15th May 2018. Therefore, for a claimant to succeed in his claim, he must base his claim based on his own right, and the claimant for not being able to pin down his claim for pension to any provisions of the conditions of service has failed in his duty. In view of the foregoing, the claimant has failed to prove the claim of for salaries and entitlement. The claimant has equally failed in his duty to prove that his salary that he is entitled to payment of pension. The claimant has not referred this court to any provisions of the conditions of service that grant him such entitlement. The claimant has been receiving salary before it was stopped. Therefore, his failure to tender his last pay slip when he has pleaded in paragraph in his pleadings is fatal to his case. The law is well settled that document pleaded is part of the pleading, and failure to tender it means abandonment of the said pleading. In the circumstances, the claimant has not proved relief of his claim. I now goes to relief 3. I now goes to relief 4, which is for payment of 20,000 general damages for unlawful termination of claimant's employment. I have earlier in this judgment found the claimant employment was wrongfully terminated. In the circumstances, the claimant for general damages is in the case of contract of employment is well settled. The law is settled that where a court found termination of contract of service to be wrongful, the claimant will be entitled to damages for the wrongful termination. Once contract of employment stipulates expressly that it is terminated by the claimant by the giving of the stipulated period of notice, the damages recoverable for wrongful termination will be the amount of wages or salary the employee would have earned during the stipulated period of notice. See the case of Obot versus CBN. See also Western Nigeria Development Corporation versus Abimbola. See also Spring Bank PLC versus Babatunde. See also Onalaja Africa Petroleum Limited. To further buttress the point being made here, I shall refer to 2 more cases as follows. In Farouk Bogo versus British Airways PLC, LPLR, 2016 LPLR, the Court of Appeal, found Nimfar JCA relied on this principle when it succinctly held on the measure of damages recoverable for wrongful termination of employment. Thus, the measure of damages awarded when an employment is wrongfully terminated is also settled in law. The Apex Court in the case of Osasian versus Africa Bank PLC held as follows. There is, in my view, no doubt that court below correctly stated and applied the applicable principle of law in master-servant relationship in International Drilling Company versus Moses Eyope Al-Ajijala. This court for Obaseki JSC said on this point, principle of law governing award of damages were stated recently by this court in Western Nigerian Development Corporation versus Jimo Abimbola and Nigerian Produce Marketing Board versus Adeumi. In the latter case, we stated the law as follows at page 437. In a claim for unlawful dismissal, the measure of damages is prima facie the amount that the plaintiff would have earned had the employment continued according to the contract, where however, the defendant on giving the prescribed notice, he has a right to terminate the contract before the end of the term. The damages awarded, apart from other entitlement, should be limited to the amount which would have been earned by the plaintiff over the period of notice, bearing in mind that it is the duty of the plaintiff to minimize the damages which he sustained. Similarly, the case of Court of Appeal, in the case of Akbar Akwe versus University Press, it was held, it should be noted, it should also be appreciated that in employment matters, the claim for wrongful dismissal, the measurement of damage is prima facie the amount that the plaintiff would have earned had the employment continued according to the contract. See NMP versus Adeumi, Beckham versus Dake, where, however, the defendant, on giving the prescribed notice, has a right to terminate the contract before the end of the term. In respect of terms of contract, the damages awardable, apart from the entitlement earlier stated, should be limited to the amount which would have been earned by the plaintiff over the period of notice, bearing in mind it is the duty of plaintiff to minimize the damage which he will sustain. In the case of wrongful dismissal, see Denmark Production versus Boscol Production Limited. See also Tenny versus Abubakar. See also New Nigerian Newspapers versus Atoye B. From the foregoing exposition of the law, the law is that generally the length of notice required for termination of contract of employment depends on intention of the parties, as can or may be gathered from the contract. And in the absence of any express provision, the code will also always imply terms that the employment may be terminated by a reasonable notice from either of the parties. And even where, as clearly provided in the agreement for persons still under probation, the employer has the power to terminate the contract in his absolute discretion, the law enjoins the employer to give reasonable notice to the employee. In the case at hand, the conditions of service and letter of appointment only provided for notice in respect of resignation and employee on probation. In the circumstances, the claimant, who is confirmed officer, is also entitled to 2 months' salary in lieu of notice, which is the same notice he is to give if he is to leave the service. All I have been saying above is that the claimant in this case is only entitled to payment of 2 months' salary in lieu of notice for wrongful termination. The employment of the claimant, having been that of master or servant, has ended, even though it was wrongful. The mere fact that the defendant did not follow due process in terminating the employment has no effect on the termination. The termination has ended the relationship. Notwithstanding, this principle of labor jurisprudence is based on the well-settled position of the law that employee will not be enforced on unwilling employer. Or relief 5, which is for payment to the claimant of the sum of 30 million naira as general damages for libel. The facts in proof of the alleged libel relied on by the claimant are as contained in paragraphs 29 to 37, 45 to 47, and 54 of the statement of claim, and the corresponding paragraphs in the witness statement on oath of the claimant and his other 2 witnesses. Apart from the claimant who testified as CW1 in proof of his case, he called his friend and his brother who testified in proof of the alleged libel as CW2 and CW3 respectively. The testimony of CW2 and CW3 wherein the claimant was have been defamed by the report of the panel of investigation set up by the defendant to investigate the safety of 3 air conditioners. According to counsel for the claimant, the finding of the panel set up to investigate was libelous of the claimant's character. The libelous aspect of the report has been set out in paragraph 29 of the statement of claim. The claimant has testified that his friend have abandoned him as well as his brother. The claimant testified that due to his libelous publication, he cannot get any employment again since his years of service with the defendant has gone with the wind as a result. The claimant also testified as to how he tried how he tried his hands in politics, but was asked to step down because of the libel that he was found guilty of theft of the 3 air conditioners. The other 2 witnesses also testified on the alleged libel. It is submitted by counsel that the testimony of CW1 and 2 and 3, exhibit CW1B to 9, the claimant has proved the libel as required by law, for which he is entitled to damages. The counsel also relied on the case of Guardian newspapers and another versus Reverend Pastor Anja. The judgment delivered on Friday, 15th day of April 2011, reported in this day newspaper. The factors that should be considered in awarding damages, claimant relied on the case of Imagwara versus Guardian newspaper. Counsel contended that conduct of the defendant since the institution of this case shows that the defendant had no regard to the court, had no regard for the court of law. Counsel asked the court to grant the 30 million naira damages. It is also submitted that the guilty verdict passed by the panel in its report is libelous of the claimant for whom the document should write a letter of apology and a retraction of the verdict so as to establish his innocence and prove to his friend that and the world that he is not a thief. The law has recognized respect for dignity of human person and the need for protection of integrity of all persons, whether human or artificial. That's why the law prohibits tarnishing image and reputation either by uttering words or writing. Libel has been described to mean a statement reduced into writing by one about the other, which statement has been published to a third party and has the effect of tendering the lowering the addressee in the estimation of right-thinking members of the society generally. Particularly, the statement caused its victim to be regarded with ill feelings or ridicule, fear, disdain, hatred, contempt. Although the claimant has the burden of proving not only the fact that the statement was in such permanent form been published, but that in addition referred to and was defamatory of him and was false. The statement is proved to be libelous if the statement is proved to be libelous, if being written and published to another had exposed the person to whom it is referred to, the statement would be defamatory. when it is shown to have lowered the victim in the estimation of right-thinking members of the society. See sketch versus Ajembeko. In any claim for defamation of character or reputation, publication is the life wire of the action in libel. Publication is an alleged publication of the alleged defamatory word is a fundamental element that must be established in an action for libel. Therefore, it is sufficient if it is proved that publication of the alleged defamatory material was made to at least one person other than the claimant in such a manner that it would convey the defamatory meaning, and that the person acquainted with the claimant understood it to refer to the claimant. See the case of Onu and Agbaje and a host of other cases cited therein. Exhibit CW1B9 is the document which the claimant alleged contains the defamatory statement. I have in the earlier part of this judgment found that document, that exhibit has no evidential value, and same was discountenanced for the purposes of this judgment. Furthermore, a careful look at exhibit CW19 will show that the document is not a complete document, as it starts with page 2. Page 1 is missing. The law is well settled that all documents tendered before a court of law are part and parcel of the evidence to be considered in determining the issues before the court. Therefore, exhibit tendered and admitted in evidence in the course of trial are subject to scrutiny and should be tested for credibility and weight by the court. Where publication, which is the sending canon that gives life to the libel case, is not proved, the case of the claimant would fail. In the case at hand, since publication was not proved, due to lack of evidential value to the document relied on in proof of the libel, the libel must fail, and same is hereby refused and dismissed. See the case of FBN versus Aboko. I now goes to relief 6 is for a letter of apology from the defendant to the claimant for the aforesaid libel and the retraction. The guilty verdict passed by the court on the claimant. This relief is an ancillary relief dependent on the grant of relief 4. The failure, relief 5, sorry. The failure of relief 5 also means failure of relief 6. Relief 7 is for payment of the sum of 30 million naira general damages for unlawful, unwarranted, and malicious report to the police and prosecution of the claimant for theft of the 3 air conditioners. The claimant's evidence in support of this relief is to the effect that on 2nd of October 1998, the claimant reported missing 3 air conditioners belonging to the defendant to HNB security. Consequently, he was interrogated by the security officer. Thereafter, the claimant was invited by the police in respect of the 3 air conditioners. The claimant was detained at the police station and tortured by the IPO investigating the report when Mr. Emmanuel Edet. The claimant was charged before the Chief Magistrate Court, Wuse Abuja, for theft of the 3 air conditioners. However, he was discharged on 6th day of October 1999. According to claimant, HNB Security was bent on prosecuting him because he want to retain counsel for the claimant argues that the claimant's action is similar to the case of Okonko versus Obogu, where the defendant reported that the plaintiff destroyed his structures. Counsel insisted that the defendant in this case has no justifiable reason at all to report the claimant because the claimant reported the missing air conditioners. There is also that the office was fenced and has barbed wire, and the ACs cannot be carried away without a vehicle. For the defendant, the claim of malicious prosecution has not been proved. Counsel submitted that HNB Security was the one who made the report. Counsel posted that even assuming HNB lodged a complaint on behalf of the defendant, the defendant will still not be liable as the police decided to go about the investigation and not the defendant. The claimant has failed to establish how the defendant was actively behind his arrest, alleged total of subsequent criminal prosecution by the police at Chief Magistrate Court. In a claim for damages for malicious prosecution, the claimant has the bounden duty of proving his assertion for him to succeed. The law has always been that in civil cases, the burden of proof rests squarely on he who will fail if no evidence is adduced. The law of malicious prosecution is settled beyond any reproach that any party that the element has to be, 4 elements have to be proved. The elements are: 1, that he was prosecuted by the defendant. In this regard, it must be shown clearly that the defendant set in motion against the plaintiff the law leading to the criminal charge. 2, that as a result of the prosecution aforementioned, the plaintiff was tried by a court of competent jurisdiction, discharged, and acquitted. 3, the prosecution of the claimant was completely without reason. 4, the prosecution was as a result of malice by the defendant against the claimant. See also the case of Maya Leke and another versus OK, CCB versus Odogu, Ojo versus Okitufu for Oil Farm PLC, Balogun versus Amu Become, Iyaleku versus Omorebe, and Iyale and others cited therein. The law also is tried that all these 4 elements must be present for successful action for malicious prosecution, and the onus is always on the plaintiff to prove each of every one of them. The most important consideration is the arrest decision, whether it is taken by the police and not by the complainant. Likewise, the decision to prosecute is taken either by the police or Attorney General in the Ministry of Justice. A case of malicious prosecution can only lie against a defendant who initiates the law against the claimant for purposes of prosecuting him. The onerous task of proving malicious prosecution is on the claimant, and it is not to be taken so lightly. The claimant must prove that the complaint was malicious in the sense that the defendant was all out to unleash havoc. The claimant must also prove that the defendant was all out to ruin the claimant by ensuring that the claimant is embarrassed there must that the mindset of the defendant is bent to at all costs to destroy the claimant who is innocent. A prosecution cannot be a mere discharge without acquittal cannot give rise to action for malicious prosecution. The prosecution can be said to be malicious if the defendant has malice against the claimant and pursuant to malice and pursues the malice by reporting the matter to the police, a matter which has not any iota of evidence to support before the court. The report and the prosecution that it must be also shown that the report and prosecution are all founded on vendetta on part of the defendant, where a claimant has an opportunity that also the claimant has the opportunity of committing the crime or was in a position to commit the crime, but the court discharged him on technical ground. A civil action of malicious prosecution cannot lie against the defendant because there was no malice at all. Therefore, a defendant who believed that he had genuine complaint against the defendant to the knowledge of a reasonable person or police is also genuine. The defendant cannot be liable to a civil action or malicious prosecution in such a situation. See the case of Ojo versus Okitifu for Oil Farm PLC. It is in line with the above exposition of the extant law on malicious prosecution that the claim of the claimant on malicious prosecution would be viewed. The position of the law is that it is not enough for claimant in a claim for malicious prosecution to prove arrest and detention for false imprisonment. The claimant must go further to plead and prove evidence that the defendant did not merely make a report against him. He must also plead and establish that there was no reasonable or probable cause for making such a report. The plaintiff has the legal burden of showing that the report made by the defendant is false, frivolous, without legal foundation. See Bayol versus Ahemba and Iyalekwi Omologe Sufra. The claimant is equally to establish by credible evidence that the defendant instigated and propelled the action of the police. In the case at hand, there was a report of missing 3 air conditioners belonging to the defendant. The report was made by the claimant to HNB security guard on duty and his senior manager. The claimant stated that he was arrested by the police based on the complaint of HNB security and the defendant sick, tortured by the IPO handling the investigation, Mr. Corporal Emmanuel Ede, including hanging, the confess, stealing of the air conditioner. Service of the statement of clear refers. The claimant further stated that the HNB security contracted by the defendant to guard his premises and properties, and in order to keep their job, was bent on doing everything to find the claimant liable for theft of air conditioners. Paragraph 8 of the statement of claim refers that the claimant and Mr. Chonkia, a staff of the defendant, and some security personnel of HNB were charged before the Chief Magistrate Court, Wuse Abuja, on theft of the air conditioners. At the end of the prosecution's counsel case, the claimant was discharged. See Exhibit CW1K123. The claimant has averred in his statement of claim that he was never at any time queried or reprimanded while the defendant's employment before the Department of Employment before the incident that led to his to this suit. The claimant has stated that his main torture, Corporal Edet, a policeman, was also doing a part-time job with HNB security. He is doing part-time job of a security man and trainer for HNB security, was the IPO for case, and he kept telling the claimant in the process of interrogation and torture that the claimant will die in detention unless he compelled to stealing 3 air conditioners. The IPO was brutal to him because he is having special relationship with HNB, that he was in detention for 9 days before he was admitted to bail and charged to court after intervention of his counsel. The claimant also stated that he ought to be commended for reporting the 3 air conditioners, but he later learned that his act of reporting the theft would create problem for HNB security for managing director, who is the in-law of the owner of HNB security outfit. For overstepping the boundaries, he must be used as scapegoat. According to the claimant, the defendant has no justifiable reason to report him for theft of 3 air conditioners or even to be prosecuted. The report was born out of malice and looking for a scapegoat to cover the lapses of HNB security. I have decided to state in extenso the facts, the evidence, the facts as gathered from the claimant pleadings and evidence in chief, which the claimant relied in proof of malicious prosecution for proper appreciation of the position to be taken by the court on the claim for malicious prosecution. The most important factor to be considered here is whether the claimant, by pleading and evidence before the court, has successfully established a case of malicious prosecution against the defendant. It is clear from the facts that the claimant alleged that he was arrested by the police on complaint of HNB security and the defendant. However, the claimant was not forthcoming to state the facts that led to the complaint lodged with the police. This is where Exhibit CW1K1 to 3, the ruling on no case submission, has become relevant, as it provided clue on what necessitated the complaint to the police on missing air conditioners. It is clear from Exhibit CW1K that PW1 that testified at the magistrate court told the chief magistrate that on receipt of the missing complaint or receipt of missing air conditioners, he went to the premises of the defendant and he got to know that the stolen air conditioners were initially kept in an open premise in an open place at the premises of the defendant for over a year, and nothing has happened to them. However, the claimant instructed evacuation of the air conditioners to a store, and he had at one time collected the keys of the stores and returns them with one over. And it was the claimant who relocated the air conditioners from where they were kept originally. And it was the claimant who discovered the missing air conditioners. Given the above scenario, it will not be out of order or unreasonable or unjustifiable to report the missing air conditioners to the police for them to perform their constitutional duty of investigation and prosecution if need be. In the circumstances, the complaint to the police cannot be unjustifiable on ground or to ground finding on malicious prosecution. It is common ground that there was theft of 3 air conditioners belonging to the defendant. Therefore, the complaint on missing air conditioner cannot be unbelievable or incredulous to be based on speculation. The claimant has not also supplied material facts on the role the defendant played in the arrest and alleged there is also no iota of evidence to show that it was the defendant that instigated or propelled the police in the action which they took in arrest and prosecution of the claimant. What is clear from the evidence of the claimant is that HNB Security was the brain behind his ordeal. The claimant behind the ordeal, the claimant passed through in the hands of the police and not the defendant. It is the pleading and evidence of the claimant that HNB Security was bent on doing everything possible to find him liable for theft of 3 air conditioners. HNB Securities HNB Security is not one and the same. It's not one and same person. It's not one and same person with the defendant. The claimant has also stated that the role of HNB Security is because in making effort to see that he was found liable is because the owner is in-law to the then managing director of the defendant. I must say at this juncture that all the pleadings and evidence regarding HNB Security, regarding the owner being in-law of the then managing director, is based on speculation, and there was no iota of proof of the assertion by credible evidence. In the circumstances, even if HNB Security is found to have the action of HNB Security is found to be to amount to malicious prosecution, that cannot be said to be the act of the defendant, as no proof of the defendant's roles has been disclosed throughout the pleadings of the claimant. It is surprising that the claimant who had so much against HNB Security as the IEPO Emmanuel Edet failed and neglected to join them in this suit. The failure to join them is fatal, as they are necessary parties in this suit. It is apt to state here that it is the duty of citizens of a country to report cases of crime to the police for investigation, and what happened thereafter is entirely the responsibility of the police. The citizen cannot be held culpable for doing their duty unless it is shown that it is done mala fide. In the case at hand, the claimant who has the duty of proof cannot rely on abandonment of defense by the defendant to succeed on evidence that is not credible. The claimant is therefore not entitled to damages for malicious prosecution due to lack of proof of malice, or that the defendant instigated his arrest and his prosecution. By the above exposition, a reasonable and probable cause has been established to justify complaint made by the defendant before to the police. See the case of Balukum versus Amu Bikon. In his own, the claimant has, in his evidence, stated that the police investigated the complaint made by the defendant against him and took him to court, but there is nowhere evidence was adduced to establish that the defendant instigated the action taken by the police against the claimant. For the purposes of the claim for malicious prosecution to be liable, the defendant must be actively instrumental in setting the law in motion for prosecution of the claimant. Within the context, to prosecute is to deliberately and actively initiate or instigate by way of indirect appeal to the press or to mount pressure on a person with judicial authority with regard to a complaint report made that the claimant be charged and put to trial. Thus, for the defendant and police in the decision to charge the claimant, the court therefore an action for malicious prosecution will not lie against a person who merely gave an information to the police by a report or complaint of the commission of an offense, which led to police on their own to initiate or resort the position is also same where report made to the police named a particular person as the suspect. In all these situations, a defendant cannot be said to have been instrumental or actively set the law in motion for the prosecution of the claimant, because the police had the option and liberty to deal with the matter with the outcome of the investigation of the complaint to them. If the evidence did not show that the defendant influenced the police in any way in the decision to prosecute the claimant, then the prosecution cannot be and will not properly be attributed to the defendant, but to the police. See also Balogun versus Amubiko. In the case at hand, the evidence of the claimant, which has been reproduced above, which has been summarized above, did not show or establish that the defendant did anything to influence the prosecution of the respondent, apart from making a report or complaint to the police. In other words, the evidence of the respondent did not show that, the evidence of the claimant did not show that apart from making a report or complaint to the police about destruction of about the commission of the offense, the defendant actively influenced the police in the decisions they have taken. In view of my finding that some of the ingredients of the offense of malicious prosecution has not been proved in evidence on the balance of probabilities by the evidence of the claimant. This ingredient of the offense of malicious appears to be foundation of the claimant for malicious prosecution. It could not, the claim automatically collapse and cannot be granted by the court. For avoidance of doubt, from all I have been saying above, the claimant in this case has failed to prove malicious prosecution against the defendant. This relief failed and same is hereby dismissed. The last The last relief is for 10% interest. This is a discretionary. This is discretionary on part of the court to award at the end of the decision if it founds for the claimant. Therefore, the claim for 10% is premature, as it will be within the province of the court to consider whether it can grant or not. From all I have been saying above, the claimant is only able to establish that his termination of employment by the defendant was wrongful and not null and void. In the circumstances, the claimant is only entitled to payment of 2 months' salaries in lieu of notice for wrongful termination. In addition to the claim, the claimant is entitled to costs, which I assess in view of the entire circumstances of this case to be the sum of 3 million naira.
As the court pleases, my lord.
Therefore, the defendant shall within 30 days from the date of this judgment pay to the claimant 2 months' salary in lieu of notice for wrongful termination and cost in the sum of 3 million naira.
As the court pleases.
As the court pleases, my lord.
3 million naira. All the monetary sums payable in this judgment shall be paid within 30 days as stipulated above, and failing which it shall attract 10% interest per judgment entered accordingly.
Court pleases, my lord. My lord, we are grateful. We've learned a lot from the judgment, and we are very grateful, my lord. Thank you, my lord.
You are welcome.
Thank you, sir.
My lord, we are most grateful for the well-considered judgment.
You are welcome.
We apologize to my lord for taking my lord out of his well-earned vacation to deliver this copious judgment, sir.
It's all right, no problem.
Thank you, my lord.
The judgment, you will get the hard copy on Monday.
As the court
As the
pleases.
court,
But before then, you can access the soft copy on our website by tomorrow. By
As
the
the
grace of
as the court pleases.
I'm most grateful.
Registrar, any other matter? Yes, thank you very much, Council, for
Thank you,
your
man.
We
Thank
have
you, my
come
lord.
to the end of the virtual sitting. The administrator, you can discontinue with the sitting. Thank you very much, Council. Have a nice vacation too.
Same to
Same
you,
to
my
you,
lord.
my lord.
Okay.
Okay. Live stream. Stop recording. So then